7 people were killed on Monday after Dalits in several states held protests against a Supreme Court order which diluted the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act. The order, released on March 20, 2018, removed a provision for automatic arrests of those accused under the Act. The judgment also stated that public servants can be arrested under this law only with the written permission of their public authority. A bench of Justices U. Lalit and A.K. Goyal also stated that the Atrocities Act was being used to blackmail innocent citizens and public servants and that it should not be used to perpetuate casteism. But this is not true. At the preliminary stage, before filing the first information report, the police will see if there is enough evidence to file the case. They came to the conclusion that only 6% of the total cases are rejected at that stage. Rest of the 94% cases are considered by the police based on the evidence to be filed. The incident has happened. The police should immediately go to the spot and file the case within 24 hours. Also, while filing the case, it should mention the caste background of the victim as well as the accused. Provide medical support and rehabilitation. An officer not below the rank of DSP should investigate, and the first information report should be read out to the victim.
None of these rules were followed by the police while dealing with these cases.
There is willful negligence by the officials who investigate the cases of atrocities, and that willful negligence is reflected in leaving several loopholes while filing the case. The loopholes in procedure are then used by the judges to acquit the person on procedural grounds. That is the crux of the failure of the Atrocities Act. It is the administration which is responsible for the extremely low conviction rates. This was the reason why the 2015 amendment to the Atrocities Act brought an additional provision that if an officer is found to be willfully negligent, an internal inquiry will be set up against him. This Supreme Court judgment takes that away.